Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elevate.net, ELAWVATE.net, or go online to elevate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elevate.net or fill out a case workshop request at elevate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elevate podcast is brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute. Welcome to the Elevate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon.
Ben, we're both in suits today for the podcast. This is pretty amazing. I'm headed to court. I'm assuming there's a lot going on with that tragedy and the ice shooting out in Maine that you've been involved in. And can you just share with our listeners a little bit about what happened and what's going to happen?
Yeah, sure. I mean, to say a tragedy, we deal in tragedies every day, but in 25 plus years of doing this work, I've never been so emotionally compelled or connected to a case as I am to this one, because what happened here is so egregious and so needless. So we represent the widow of Joan Sebastian Duran Guerrero, who is a Colombian immigrant, 25-year-old guy with a beautiful partner and a beautiful 3-year-old daughter who came to this country to help build himself a better life. Extremely hard worker, doing everything lawfully through the immigration system, had a court date for his citizenship application. And a week ago Monday, an ICE officer shot him dead while he was driving, just pulling out of his apartment to drive himself to PetSmart, where he worked. And like many of these other ICE-related shootings, well, first of all, in this case, the government did acknowledge that he was not even the target of their operations. There was no suggestion he had ever done anything wrong, he never committed any crime. But like most of these other shootings, rather than doing what's right, apologizing, or taking any action to make good to the family or to prevent this from happening again, the government has not only taken his life, but has tried to impugn his and slander his character and his dignity after his death by labeling him, an alien or an illegal, by suggesting he did something wrong that may have led to the shooting, all of which is completely false, completely bogus. Basically, everything the government has said about this is provably wrong, as it has been in many of the other cases where they made initial statements that were then proven to be false through video that was discovered later. So this is fast moving and embroiling of our community and the nation in certain respects. And then, as our guest Robert Hirschhorn just pointed out before we went on air here, that multiple ex-wives of the shooter have now come forward saying that he had a long history of mental illness, apparently had severe diagnoses, including things such as bipolar condition, brain injuries. He had a history of violence toward his ex-wives, threatening to kill them, behaving violently, things such as throwing boiling hot water at them. He physically assaulted his child, all of which is reported in various court records that have now been pulled from different courts in Maine. So, had anybody reasonably vetted this person for the job, they would have determined he was completely unfit and not suited for this role. But my theory about it is that the government doesn't want to vet people because they want people like this in these roles. That's my soapbox 60 seconds version of it, but we should move on to the topic of the day. But I'm fired up and very angry about all of this, obviously.
Bring justice on that and bring it quick, Ben. I mean,
Yeah,
that's just awful. It's not
yeah.
what this country should stand for in the least.
With that segue, sorry, Robert. It's our pleasure to have Robert Hirschhorn on the podcast today. Everybody who listening probably knows Robert Hirschhorn. He's probably the most famous, most well-respected jury consultant who has assisted trial lawyers in the last couple decades in America. He's been a regular feature on many national news broadcasts. He's been involved in many high-profile cases. I learned about him from the Arnold and Itkin firm. I know he's worked on a lot of cases with Jason Itkin to great results. He's also founded a new AI technology that we've recently worked with, which I thought was great, called, I think it's VerdictHub, right?
It is VerdictHub.
Yeah. So we'll get into that. But before we get into that, Robert, can you just kind of talk a little bit more about your background and how did you come to all this? And how did you become kind of the gold standard, at least in our perspective, for jury consultants and for trial lawyers in America?
Can I just throw one thing in before you say something, Robert? Just to add to the accolades, Mark Lanier swears by Robert Hirschhorn, uses him for all of his trials. And we all know Mark gets some pretty amazing results and justice for his clients. And so I had the privilege of getting to work with Robert on the first social media addiction trial that was tried here in LA Superior Court and got a great outcome. So I can say firsthand, Robert, you're amazing.
Oh, you're very kind. Appreciate it. Appreciate y'all inviting me onto your podcast. Ben, I got to tell you, lawyers like you and Rahul are what make us proud to be lawyers, because what you're doing, for example, with that Maine case, what I've seen the work Rahul do, y'all make us proud. So thank you for doing everything that y'all do. So let me tell you a little bit about kind of how I got into this. I was a young lawyer. I was doing criminal defense in San Antonio, Texas. It's the early 80s. I won my first 12 jury trials. I thought I was going to be the next Racehorse Haynes. I thought I was going to be America's next great criminal defense lawyer. Client comes into my office one day. He's a law enforcement officer charged with aggravated assault, and he's also charged with robbery. And so he comes into the office. He tells me the facts of his case. I can't think of how to win this case. There's 5 eyewitnesses. He's caught 100 yards from the alleged crime. He's found with an Uzi, a sawed-off shotgun, and a 22 with a silencer. I mean, right? These are not good facts. So I went to my boss and I said, Jerry, what do I do? And he said, you got to hire Cathy Bennett. And I said, who's Cathy? This is 1984. I said, who's Cathy Bennett? He said, she's a jury consultant. And I said, what's a jury consultant? Right? I'm a 3-year lawyer. I don't know any of this stuff. He says, Robert, stop asking all these questions. Go call Cat. I called Cat Bennett. I talked to her. I convinced her to help us with this case. We go to trial. We win the case. We get an outright not guilty. I turned to Cat Bennett in 1984 and I said, you have changed my life. I want to learn to do what you do for a living. And here's what Cat Bennett said to me. She said, Robert, if you're serious, I'll do this. But for 1 year, you have got to be a sponge. So when we have our meetings with clients, or we're in a jury selection, or if we're doing witness prep, I don't want you piping up. I don't want you talking. I just want you to be a sponge. Now, for those of you that are trial lawyers listening in, we're all type A personalities. Can you imagine putting a muzzle on for 1 year where you can't say shit? You can't say anything. I did it. The greatest, by the way, the greatest closing argument I ever gave was when I convinced Cathy Bennett to marry me. So I got to I got
Wow.
to change my profession. I was blessed to be married to Cathy Bennett. And it's been just, I've been so blessed with such a remarkable career and work with great lawyers and do really meaningful work. And so that's why I feel so blessed that every single day, to me, it's like a holiday. That's how much I love the work that I do.
And does she let you talk now?
She did. So here's the story with Kat. So almost 1 year to the day after Kat and I got married, she felt a lump in her breast. Women,
Oh,
do your breast exams. The life you're going to save is yours. Please do it. Felt a lump in her breast. By the time we had discovered it, it had already metastasized to her lymph nodes. Kat and I went all over the world looking for the cure for breast cancer. In fact, 6 months. I mean, this is what a trooper she was. I mean, she not only was one of the founders of the field of jury consulting, Kat was, she was such a trooper. She was such a true believer. She believed so much in helping the person accused or the little guy that she's on her deathbed. She gets out of her deathbed, goes to Florida, helps Roy Black, may he rest in peace, helps Roy Black and pick the jury in the William Kennedy Smith case, got the not guilty in that case. And then 6 months after that, Kat passed away. So,
mm.
you know, y'all, when Kat passed away, I had to make a decision. Kat had given me these really remarkable tools, and I could either go back to practicing law and just crush it as a lawyer, as a trial lawyer, or do the best I could to keep Kat's memory and her vision and her view of the world alive. And I chose the latter path because to this day, when people call my office, the phone is answered Cathy Bennett and Associates to this day. And that's how I want to end my life, is my phone always being answered to that announcement. Quite the story, huh?
That's amazing. So, Robert, tell us about the evolution of jury selection, trial strategy from the Robert Hirschhorn perspective. How did it
Yeah.
start, and
Okay.
then how has it evolved?
Yep. Okay. Here. So here's controversial statement number one. I spent 30 years advocating for jury questionnaires. You should always have a jury questionnaire. I would push lawyers, I push judges, I do everything I can. Here comes the controversial part. I've now done a 180. I now don't believe in questionnaires anymore, except in very limited circumstances. And those limited circumstances are when you've got a very controversial or contested liability case. But as a general rule, if you've got strong liability, I don't think you want a questionnaire anymore, because what corporations are doing with that information, especially with the advent of artificial intelligence, which we're going to talk about a little later in this podcast. I know what these corporations are capable of doing because I'm in that space now. I'm in the artificial intelligence space. I know what they're capable of doing. And I'm talking about the bigger cases. In the bigger cases, I'm telling y'all, you don't want a jury questionnaire anymore. It helps the defense more than the plaintiff does. All right. So let's talk about kind of the evolution of the jury consulting world. When I started, 90% of the cases that we worked on were criminal cases because the civil lawyers didn't really know about jury consulting in the 80s. I mean, that really was the infancy of this whole profession of jury consulting. So the vast majority of my clients were doing criminal cases. We were doing regular run of the mill cases. We were doing high profile cases. And then it caught on with the civil lawyers. And now the civil lawyers, in virtually every case of substance, they are using some form of jury consulting in their cases, whether they hire a jury consultant to help with a focus group or with a mock trial or write voir dire questions or be in court and help them with jury selection. The whole field of jury consulting has exploded. So when I started, let me just tell you, when I started as a jury consultant in 1985, after my 1 year keep your mouth shut period ended, there were probably 100 jury consultants in the whole country. today there's thousands of jury consultants. So the profession of jury consulting has really exploded. I think it's done a lot of good. I think there's some people that do things in the jury consulting field that I'm not proud of, just like there's lawyers that do things that I'm not proud of. But by and large, it's been a great addition. It's provided a great service to lawyers, honestly, on both sides of the V. I don't work on the defense side of the V much anymore. I would say maybe 2%, maybe 5% of the time. As long as it's not a personal injury case, I'll help in a business dispute. But I think jury consultants really do help both sides of the V.
This is the first time I'm hearing that there's thousands of jury consultants because I only work with a very small handful of them. Knowing that there's some that do only defense and some that do only plaintiff, that still is a large number of jury consultants out there. For a trial lawyer who's contemplating using a jury consultant not named Robert Hirschhorn, can you give any advice on how they can distinguish between someone who's giving them science and professional advice versus potentially a
Yeah.
scam?
Rahul, as usual, great question. Fabulous question. Okay, number one, get references. Ask them for names of lawyers that they've worked with and call them. Okay. Number two, ask that person why they became a jury consultant. You want to find out what motivates them to do what they do for a living. You got to learn, are they doing it because they love what they do or it's a job that pays them well? And there's a difference in people's mindset. That's why you got to understand why they do what they do. If they've written any articles, ask to read any articles that they've written. And of course, you should Google them and find out as much information as you can about them. Jury consultants, again, are like lawyers, doctors, accountants, used car salesmen. There's good ones, there's shitty ones. You don't want to end up with a shitty one because you're just going to have a bad experience. We just got called on a case where a jury consultant had done the focus group for the lawyer, basically made all the money in the case. And when it came time for jury selection, the jury consultant said, oh, by the way, I'm not available to help with jury selection. It's like, you got to make sure if you're going to hire a jury consultant, give them the date of your trial and make sure they're available.
Robert, as you know, the availability of attorney-directed voir dire varies dramatically state to state and venue to venue. I think often these discussions come out of states that have fairly liberal rules, but then lawyers that are in venues that have more restrictive approaches can sometimes feel underappreciated or as if this doesn't talk to them. What advice or strategies do you have if there's stringent limits, maybe time limits or number of questions, or you have to preview your questions in advance, or you have to use questionnaires, or the various, I'm sure you've seen all different iterations of restrictions.
I have. Here's what I can tell you. 10 minutes of attorney voir dire will always be better than an hour of judge conducted voir dire. And the reason is because, and lawyers, you all know this, jurors aren't going to tell judges what they honestly think in the majority of cases. They tell the judge what they want to hear. They don't want to argue or disagree with a judge, especially if they're like a federal judge. So that's why judge conducted questioning, judge conducted voir dire is never particularly enlightening. The only people that are going to raise their hand or open their mouth are the people that have a really strong voice. They will speak up. They will not be afraid. But the vast majority of your panel won't speak up. So here's my point. If you're in a venue that has really restrictive rules regarding jury selection, attorney participation in jury selection, like either it's a severe time limit or even worse, a no time limit. The judge does all the questioning. You gotta submit judge questions to the judge. Here are my two rules. Number one, if you're in a venue where there's no attorney participation at all, okay, file a motion and request 10 minutes of questioning the jury, 10 minutes of voir dire. That's all you want to ask is 10 minutes. That's number one. Number two, if you're in a venue, I mean, look, any judge, if all the lawyer, how much damage could a lawyer do in 10 minutes, right? Think about it from the judge's perspective. What the judge doesn't want is The judge wants the jury picked, the opening's done. The judge wants the case done as quick as possible. All right. They're just afraid you, as a lawyer, you're going to spend all this time picking the jury. No, 10 minutes. All right. File that motion if you're in a venue that doesn't allow. I don't give a shit if there's case law on it. I don't care if there's a local rule on it, if that's the judge's rule. I don't care. File the motion, because eventually one day some judge will say, what the hell? I'll give you 10 minutes. Hell, I'll give you 5 minutes. Right now, what do you do in the 5 or 10 minutes? I'll tell you that in just a second. Here's the next thing. If you have to submit questions to a judge, if your jurisdiction requires you to submit questions, do not submit 50 questions. Stop doing that. What you want to do is submit 2, 3, 4 topics. And within those topics, the questions that you need. But you're not wanting to submit a whole bunch of questions, because the judge is only going to pick the ones that he or she feels most comfortable asking. And those are never the questions that you need the answers to. Okay. Limit the number of questions that you're going to submit to the judge. Now, back to the 10-minute voir dire. You ready? Do what we call scaled questions. I've been pitching this for, Lisa Blue and I have been pitching this for 20 years now. A scaled question is where you ask a question and you ask the panel on a scale of 0 to 10. We use a 0 to 10 scale. On a scale of 0 to 10, how strongly do you agree or disagree with that concept? Here, I'll give you an example of a scaled question. If the plaintiff has proven their case by a preponderance of evidence, I would find in favor of the plaintiff. 0 is I disagree. 0 is I strongly disagree. 10 is I strongly agree, right? If you prove your case, jury should find for the plaintiff. Now, that seems like a no-brainer to us. Everybody should say 10. But you'll be surprised. You might have jurors that say 5, 6, 4, right? So if you have 10 minutes, you want to do 2 or 3 scaled questions. That's how you use your 10 minutes, because you're going to get information from every single juror. You can not only weigh and measure them, but you get to measure them against each other, so you can intelligently use your peremptory strikes.
So on that example, you have, let's just say you ask that question, 12 jurors, 8 of them say 10, and then a couple say 8, and then somebody says 5 and 6 and 7. With this 10-minute voir dire, do you get to ask the 5, 6, and 7s why, or do you just take that number and just use it as a data point?
Data point.
What if they think that 5 is just like, hey, I'm unbiased, so I'm just right in the middle, guys, whatever it is. Obviously not listening to the question, because the question assumes the fact that you proved your case.
Yeah.
But what do you do with that?
I got it. I'll take that 5, because I want to have 1 or 2 more data points in addition to it, Rahul.
Yeah.
Because scaled questions don't give you challenges for cause. They might identify an area for cause, but just because somebody says 0 or 1, that in and of itself is not cause. You then would have to follow up. So if you get a 5, if you get a 3, 4, 5, or anything higher, you don't have time to follow up. If you get a 0, 1, or 2, yes, you need to follow up with that juror. The follow-up is 1 question. It's very simple. What I hear you saying is, even if the plaintiff proves their case, you would still not feel comfortable, or you would not be able to find in favor of the plaintiff. Is that fair to say, or do you agree with that? And that's how you got to try to get the juror into cause. But in a really restricted voir dire, sorry, I'm in Texas, we call it voir dire, bear with me. In a really restrictive environment, you don't have time for much follow-up. You can maybe do 1, and it has to be with the outliers, not the people in the middle.
Well, let's talk about the opposite situation. You have the optimal voir dire. What does that look like?
Yeah. Okay, here comes the next controversial thing I'm going to say. Jason Icken disagrees with me. I'm going to start by telling you a story. Had a case down in Louisiana, a person that was on drugs working in a company vehicle on methamphetamine or something, hits the back of a vehicle, kills a little 4-year-old girl. Okay, we did a focus group in the case. We knew we had a strong case. And I said to the lawyer, you have unlimited time for voir dire. Now, in Louisiana, the way it works is it's kind of like in LA or in California. You have jurors in the box. You talk to those jurors in the box. The ones that are for cause, they get replaced. Once you have everybody in the box cleared for cause, then you exercise your peremptory strikes. Whoever is instruct is now become a juror. They go off to the jury room. They refill the box. They start it over. So they use rounds in Louisiana. It's actually not a bad system. It's my second best system, not my first. My favorite is talk to the whole group at once. Okay. I said to the lawyer in this case, you have unlimited time. How long do you think you ought to voir dire for? Lawyer said, I don't know, Robert. I was thinking about going about an hour. I said, you're close. Take off 58 minutes. And he said to me, you want me to do a 2-minute voir dire? 2 minutes. I said, well, if I had my way, it would be 30 seconds, but yeah, I want you to do a 2-minute voir dire. So he says, all right, what do you want me to ask? I said, here's what I want you to ask. I want you to ask this question. Is there anybody sitting there right now that says, I just can't be a fair juror in a civil case for whatever reason? I'm going to start out favoring the defendant. Is there anybody on the panel saying, I'm going to start out favoring the defendant? I know you don't know anything about the case. Is there anybody sitting there favoring the defendant? Nobody raised their hand. Lawyer turned to the judge and said, Judge, we passed the panel. Okay? Remember the movie The Exorcist? Remember that scene where that little girl's head did a 360, right? In The Exorcist? Okay, it's like this that's what the defense lawyer's head did. He did like a 360 when this lawyer sat down after about a 90-second voir dire. He then spent 2 hours doing voir dire. The jury hated him. Okay. Now, in the second round, we went maybe 5 minutes because we figured out where he got some of our jurors off for cause, and we had to do what's called, we inoculated them. We told the jury what was coming and tell them, you haven't heard the evidence. If the lawyer asks you about this, just if you can wait to hear the evidence, tell them that. Okay. The point of the story is, by the time voir dire was over, the jury hated the defense, and we knew it from their verdict because they came back with a $440 million verdict for a single plaintiff. Okay, so here's my point. Just because you have unlimited time doesn't mean you need to use it all. I mean, what you want to do is ask yourself, not how much time do I need? How much time do I want the defense to have? That's the question. How much time do you want to give the defense lawyers to do their voir dire? And the less time you give them, the less time they can rehabilitate the jurors you're going to move for cause on, the less time they can identify their unfavorable jurors. So again, I want you all to rethink the whole idea of jury selection. And rather than trying to get as much time as possible, try to think about, how can I do this jury selection in 30 minutes or an hour? Even if you're in a jurisdiction that puts no limits on it, try to limit your voir dire to 30 minutes or an hour. You need an hour if it's either a high profile case or you have hotly contested liability facts. But if you're and by the way, here's the next point I want to make to y'all. You got to decide, am I picking a liability jury or a damages jury? Because the mistake a lot of lawyers make is they try to do a little bit of both. That's not the way you pick a jury, brothers and sisters. The way you do it is you got to ask yourself, am I trying to get a jury that's going to say yes because the damages will just naturally flow? Like, I'm literally waiting a verdict right now, okay? And I know that if the jury answers yes, we're going to get a pretty good verdict, okay? So we picked a liability jury because we knew damages would take care of themselves, okay? So ask yourself, am I picking a liability or a damages jury? If you're picking a liability jury, jury selection takes a little longer. If you're picking a damages jury, cut down your voir dire. Try to do it in 30 minutes, 45 minutes tops. If all you're trying to do is identify the jurors that, if supported by the evidence and allowed by the law, could not award money for things like mental anguish, pain and suffering, loss of companionship.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. psrplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at psrplaybook.com and learn from the best.
back to that example about the 30-second voir dire. I saw Rahul's face contort and
I
so
tried to
forth.
keep my poker
Uh,
face, but my
Didn't work.
inline just went
it
upside
did
down.
occur to me that that's a good way to put yourself out of a job, but I hear what you're saying, I think. I just want to make sure I'm understanding this right, is that when you have a really powerful liability case, and you've probably already studied that using tools such as VerdictHub or focus groups that you're about to get into, you already know before you step your foot in that courtroom that 80 or 90% of people are with you. So all you're doing by prolonging voir dire is giving the other side an opportunity to find sympathetic jurors, and you're better off keeping it brief. Whereas if you have a really hard liability case, that's where you might need to take 30 minutes, an hour, a couple hours, right? Is that what you're really telling us here on that issue?
Exactly right. Exactly. But look, this you can't base this on instinct, okay?
Yeah.
You've got to base this on some empirical data. You've got to do live focus groups. You've got to do something like VerdictHub. You've got to get data to support what your instinct says. We had that data, and that's why, because I'm telling you, I've picked 1,000 juries in 40 years. 1,000. This is the first time I've ever done that. And it worked like a champ.
Yeah.
It's a very rare case where you can do it. I'm just telling you.
Yeah, I just didn't want our listeners to all go out and start doing 30-second jury selections in every
No,
case. That's not what you're saying.
no,
Right.
no, no,
Okay.
absolutely not. But when you've done all the research, when you have the empirical data, when you know you've got a really strong liability case and profound damages, you get a little 4-year-old girl that burns to death in the back of a car. You don't need to do very long voir dire, or a child that gets crushed, or an elderly person that gets run over. You don't need to do a whole lot of voir dire in terms of damages. It's all about the liability case, and I'm advocating make it short. Because remember, here's the thing, especially with these younger jurors are different. Here's my next rule. Please, if you've got a lot of young jurors on your jury, don't keep repeating the same stuff over and over. It turns them off, it pisses them off. Young jurors get it the first time. They are lightning fast. They are used to everything, because of our phones, because of social media. They do everything in lightning speed. So you don't have to keep repeating stuff if you have young jurors. So my point is, you got to really do things quickly. That means jury selection, opening statement, directs. It depends. You may not be able to do directs real short, but crosses, you need to try to make your main points and cross and get out. Closing argument. By the way, in closing argument, I always think you need to reserve more time for rebuttal than you do the opening of the closing, because the defense can't stand up and say anything. So stop, limiting your rebuttal to like 10 minutes. I would do half my time in the opening part and then half for rebuttal for closing. But my point is, especially younger jurors, they want things done quickly. Judges want things done quickly. It's time to retrain yourself to do things quickly.
So just to follow up on this, and this may be a perfect segue also, developing your voir dire and your trial strategy requires a plan. And that plan means working up and going through focus groups and other types of data. So what's the Robert Hirschhorn plan to establish a plan for actually doing an effective voir dire on that case?
Yeah. So again, you got to start with the empirical data, right? And then once you have your empirical data, you now know what's resonating with people and what's not. What's not resonating with people, there's a part of your case that jurors are struggling with. You see that either from doing the VHS, the Verdict Hub survey, or from doing a focus group. That's where you need to focus your jury selection on, to identify who are the people that are of that ilk, of that mindset, that they are going to struggle with that piece of the case. So you could either try to get them off for cause or use a peremptory strike on them. That's really the main thing. When I was a baby lawyer, like, we had all day to pick juries. We tried our whole case in jury selection, right? Those days are gone. And by the way, do not let defense lawyers ever use the word nuclear verdicts, ever, ever, never, ever let them say the words nuclear verdict to a jury in jury selection, opening, closing, anywhere. Okay, number one. Number two, please don't let defense lawyers get into the facts of their case. It's wrong for you to get into the facts of your case. It'd be wrong for defense lawyers to get in the facts of the case. So please make sure you stand up and object if they're getting into the facts of the case during the voir dire. The thing you got to do now, there's new tools out there available to lawyers. Okay. And so let me use this as the segue into VerdictHub. Let me go back to Cathy Bennett. Kat's on her deathbed. And she says to me, Robert, you have these amazing tools now. Figure out a way to give them to lawyers that can't afford to hire you, that the cases don't justify it. They just can't afford to have you. But you got to figure out a way to help them, Robert. Can you make me that promise? And I said, Kat, I will make you that promise. And when Kat passed away, I said to myself, I will always do pro bono cases because I couldn't think of any other way to keep my promise to Kat. I always, throughout my entire career, I always did pro bono cases like all lawyers do, all jury consultants do. We should give back that way. But then an opportunity came to me with VerdictHub, and it was my way of fulfilling my deathbed promise to Cat Bennett, okay? Which is, this is now a vehicle where lawyers can get the benefit of kind of the Robert Hirschhorn, I call it magic. They get that magic by VerdictHub, because what we've done with Verdict, let me tell you what it is. It's venue-specific surveys that are done by artificial intelligence. Now, look, I know a lot of lawyers are freaked out about artificial intelligence. We've all read about lawyers getting cited for relying on artificial intelligence for citations, and it turns out they're fake citations. Those are called hallucinations. I get it. I was one of those people too. I got it. That's why we spent 4 months beta testing it. It's why I said to my partners, my reputation, my name, my word is on the line. We are not having a single hallucination in any of the reports that we do for VerdictHub. So that's why we put a lot of time and effort into making sure that there weren't going to be those hallucinations. So look, what we do is we can do venue-specific surveys based on artificial intelligence agents. They're called agents. I hate the word agents. We call them digital jurors. Artificial intelligence not only can tell you the demographics of your venue, no matter where in the country you're trying your case, it can not only tell you demographics, it can tell you the mindset of the kind of people that get called for jury duty. Because artificial intelligence is reading all of the everything that's in your local newspaper, whatever Facebook or social media that's public, artificial intelligence can gather that all. Okay. So we're able to figure out what the mindset are of people in your particular venue. And here's what you do. You put together a case overview for the plaintiff. You you do a case overview for the defense. All the stuff you got to do to get ready for mediation, all the stuff you got to do to get ready for a trial, all the stuff you got to get ready to do a focus group. Plaintiff case overview, defense case overview, a jury charge, a verdict form. We run that through our system. You will get a 20-plus page written report. It will tell you the strengths of your case, the weaknesses of your case. It will rank your evidence. It will give you somewhat of a jury profile, but I'm telling you, don't rely on the jury profile that much. It's a guide, not a Bible, because this is a survey. What VerdictHub does is a survey. It surveys the equivalent to 500 people in your venue, but they're digitally. 500 people in your venue is what it does. The feedback you get is phenomenal, by the way. And here's the thing, because this is all a tribute to Cathy Bennett. Not only do you get your survey, you get 3 free reruns. You get your results in 3 business days, and it costs you $3,000. Okay. So you get the equivalent to 2,000 digital jurors giving you feedback on your case, right? If you do your original survey and 3 reruns, that's 4 runs of your case. That's 2,000 digital jurors. But the idea is you get the 3 free reruns, you get the results in 3 days. The idea is, and it's $3,000. By the way, that's a trilogy. Jurors learn in 3s. Father, Son, Holy Ghost, Red, White, and Blue, Good, the Bad, the Ugly, Came, They Saw, They Conquered, ABC, CBS. Where Ben's going on tonight, CNN, jurors learning threes. Don't know why, don't give a shit why. I know they do. Every case has a trilogy, have your trilogy. That's why we do 3 free reruns, results in 3 days, $3,000.
I just have to say we used VerdictHub in my most recent case that went to trial. I was extremely impressed with the results that it produced. We have been doing big data now for the better part of 5 years. In the past, we've always done the classic survey, human survey-based data.
Yep.
And in this case, because we wanted to understand the costs and benefits or the limitations, qualities of each, we did the big data and we did the VerdictHub. So we were able to compare them head to head. So
And?
I'll tell you what my takeaways. The feedback and theme and case advice was more detailed and more helpful from the VerdictHub report than the big data real live jury study. It broke it down in ways that were more actionable and more useful for us in terms of framing and building our case. So that's number one. With respect to the juror profiles, the big data was better for that because, we had talked about this with your folks, Robert, that we were trying an emergency department case. The VerdictHub suggested that we should be picking emergency medicine professionals, that they were the best possible jurors for us. We know from our experience that that's untenable, and we didn't rely on that. But you guys were forthcoming in telling us that isn't its strength, and so we didn't put a lot of weight into that. I have to say the jury profiling stuff you get with the other data is itself not that great either. So it's an inexact science either way. One thing I like about the VerdictHub is one thing I've always worried about the big data is number one, it isn't venue specific. And so when you're in a small rural place like Maine,
Yep.
in order to get enough survey participants, they're using people all over the country.
Yep.
And it's difficult to model the attitudes of people in your local community. So that's the difference. Also, if you're using live humans, there's the selection bias because most people aren't sitting at their computers waiting around to do surveys. And the people that do may self-select in ways that are not representative of the broader jury pool anyway. And there's no way around that with live humans. So I feel like the AI, that is a solution to that problem. And then there's the problem of attention, because if you're presenting a complex case, multi-page, the human survey takers have to pay attention, read it carefully, and understand it. And there's always a doubt in my mind about people that are earning $100 for, an hour of their time, give a shit about your case enough to read it carefully. So the AI solves for that. And then finally, the cost is dramatically different. A single live human survey is in the range of $25,000 to $40,000 for 500, give or take, jurors, whereas the VerdictHub analysis gets you that for $3,000, and then you get multiple free repeats. And a lot of times in my mind, it's the iteration that's valuable because you can see how changes produce different results. And when you're spending 25 to 40,000 for each survey, it's very hard to iterate. I mean, think about how many VerdictHub studies you could do for the cost of a single human survey. So I'm not saying we're going to move entirely to AI-based surveys. There may still be a role for the human-based surveys, but
There is.
I'm very convinced that this is an extremely valuable tool that the cost benefits weigh heavily in favor of at least utilizing it as an adjunct, even if you do intend to continue using human surveys.
Yeah, let me
Sorry
tell
for
you
the
this.
long-winded thing, but that was my experience.
Let me tell you a story. So we did the social media. By the way, here's Mark Lanier's take on VerdictHub. Mark Lanier's only criticism of VerdictHub is we don't charge enough money. We're too low. But I told you all why we're too low, because I'm keeping a promise to Cathy Bennett. That's because I want to bring it to lawyers. Okay. By the way, and before I tell the story, one more thing. If you are practicing in a small venue, you can't, if your case is in a small venue, you can't do a live focus group because you run the risk of it getting back to the other side, the media picking up on it, the judge hearing about it, the judge accusing you of witness tampering. There's all sorts of issues like that if you're trying cases in small venues. VerdictHub using digital jurors. By the way, digital jurors, they don't have to make dinner. Digital jurors, they don't have to put their kids to bed. Digital jurors, they don't have to worry about paying their bills. That's the beauty of all this. You have their attention the whole time. All right, here's a story I want to tell you. We did a VerdictHub in Mark Lanier's Meta case. Okay. And what we learned from the VerdictHub, the VHS, we call it VHS, VerdictHub survey. Okay. What we learned from the VHS is that we're going to have a difficult time in terms of the case against Instagram. In the case that we did for Meta, we did a VHS. And from the VHS, we knew two things. Number one, we knew that the case against YouTube was going to be a lot tougher against YouTube than it was going to be against Meta. So we knew that going in. And then we did a live focus group and it reconfirmed that whole point. But here's the second thing. This is fascinating. VerdictHub also gives you value. It also tells you what the digital jurors, what they think your case is worth. So you learn about liability, apportionment, if that's relevant, but damages too. What VHS predicted the damages to be in the social media case, the case we did in LA with Rahul and Mark Lanier, it predicted an average verdict of $3.6 million, and the actual jury verdict was $3 million. Now, look, even a broken clock is right twice a day. I got that. Maybe we just got lucky, or else maybe we were onto something. The other thing I can tell you from our focus group, our live focus group, one of our three groups in the live focus group awarded $3 million in damages. And the ask, Raul, as I remember, you didn't do an ask, right? You didn't give the jury a number, which is exactly what Mark Lanier did. Mark Lanier did not give a number either. But VHS came in the range. The live focus group came in the range of the actual jury. These are really good tools. And I'm telling you, lawyers, you need to do it for your client. It's going to come a point in time. By the way, defense firms are doing it too. I'm getting calls from defense lawyers all the time trying to hire us. And we tell them, and by the way, this is the other thing your audience needs to know. VerdictHub is not available to defendants. We don't help big law. We don't help corporations. This is for plaintiffs' lawyers only, because as far as I'm concerned, you're doing the work of the Lord, and I want to be by your side and do everything I can to help you. So that's why we're not offering to corporations, and that's why we're not offering to big law.
In the case we did where we compared the big data study with the actual jurors versus VerdictHub, both on win rate and values, the numbers came out within 1 to 2% of one another. And it was remarkable to me because they were both completely independent of one another. So whatever the methodology is, if you assume that live jurors may be the gold standard for things like win rate or value, the VerdictHub was within, like I said, 1 to 2% of that. So that was pretty good. The one thing I really wanted to have you on, the thing that worries me or that I can't get my mind around is I don't understand how the fucking thing works. Could you just give us, we don't want your algorithm or proprietary thing, but I mean, how the hell is this possible to do this? And is it something that, how can we have confidence in it? Because it's such a black box, you know what I mean? And it's not an issue of hallucinations. It's just what's the methodology that allows these so-called AI jurors to act like humans and evaluate a complex case and then give you feedback. Can you just talk about that for a second?
The answer's simple. Artificial intelligence is really smart. That's why there's big data. That's what they do. We do smart data. Artificial intelligence has access to all this information that if we had access to all this information, we could do it too, but we don't. Think about it. They have access to everything in the newspaper, everything on the radio, everything on the TV, everything that's in a public profile, all of social media. Artificial intelligence can analyze all that data in a snap. And so what we've done is our patent pending program is a combination of multiple LLMs, large language models, artificial intelligence. You've heard of Perplexity, you've heard of GPT, you've heard of
Claude.
All of them, right?
Yep.
They're all out there. We're a combination of a number of them because all of them have different strengths. Some of them are better at writing reports. Some of them are better at analyzing videos. So what we did is we took a combination, and that's how we created our program for VHS. If you can just wrap your mind around the idea that there's all this data out there that like here, paralegals. Paralegals have to take a file and a lawyer gives them an assignment and they have to go through all this data to get the lawyer the piece of information that they need. It might take a paralegal a week to do it. Artificial intelligence can do it in 10 minutes, five seconds, depending on how much data. That's my point. It has the ability to gather all this data and then analyze it. Now, here's what
Can I just add, like you have a juror, a particular juror, the AI knows that this juror is an emergency medicine nurse. That's what the juror does for a living. Like, how does it knows that 5% of the population in that county work as emergency medicine nurses. So 5% of the pool should be emergency medicine nurses. And then it's figuring out, well, an emergency medicine nurse tends to read these kind of publications or have these kind of points of view, but some do, some don't. So, I mean, and
Right.
you know, where did this person grow up? Where did they go to high school? Like I don't know. Can you just, it's just so I'm trying to understand how that is.
Look,
Could you tell me what's the
yeah,
biography of a particular one of these 500 jurors? Is there a biography of who they are as a person and their background and experience, or is it just all of that shortcutted to kind of this is where like they're how they process and respond to information?
you are getting 500 artificial intelligence agents, 500 agents. We call them digital jurors because they're not real. 500 separate digital agents with various backgrounds in your community that are looking at it. And what artificial intelligence does is it just uses math and uses knowledge to kind of figure out who are the people that are most likely going to show up as in jury duty for this particular case. What no survey does, it can't take challenges for cause into consideration, and it doesn't take peremptory striking into consideration. You're just getting a feel for what the community the jury pool community thinks about your case without consideration of cause, peremptory striking, or jury deliberations. That's why I say you don't want to put a whole lot of stock in the jury profile, because that is all depending on the individuals that show up in the courtroom. You use it as a guideline, not as a Bible. Now, like on your particular case, Ben, look, I can understand why artificial intelligence thinks that emergency people that work in medicine might be good jurors in a medicine case. I get why it thinks that, because that's who would have the most knowledge. Artificial intelligence doesn't have the training of being in the courtroom, the wisdom of being in the courtroom, because we all know that it takes a remarkable person who's in the medical field to put them on a jury in a medical malpractice case. They've got to be really the right juror, because they're either going to be your best juror or your worst juror. There's no doubt about it. So you got to choose cautiously. And that's the art of the jury selection. See, artificial intelligence isn't going to replace me anytime soon. It's coming. The day's going to come when they can even do what I do. That's not coming right now. But that's why the art of being in the courtroom, the lawyer's instincts, the lawyer's intuition, the lawyer's eyes, the lawyer's ears, all that matters in jury selection. And I can't do that. You know, VerdictHub can't do it. Big data can't do it. We can't do any of that piece. We can just kind of give you starting points, not ending points.
Just on that, a couple of thoughts. One thing, VerdictHub, for those who haven't used it, you should use it and use it the right way, though. Like Robert's even saying, it's data, and data is something where there's parts of it that'll be helpful, there's parts of it that won't be helpful, and you just got to kind of use your institutional knowledge and then pressure test it with live focus groups and other ways.
Yep.
I'll just give an example. This is an example that I'm going to explain as to what my thoughts are as to how it evolves. So I did big data on my jujitsu trial down in San Diego with John Campbell. And I told Robert about this. And John said, you should ask for around 70 million and you'll get a verdict around 48 to $50 million. And that's where it came out. And so when Robert was reaching out to our firm, he said, try VerdictHub. And I said, I'm going to give VerdictHub the exact same data I gave John Campbell. Let's run it through VerdictHub. And it said, if you're taking it just as a conclusion number and saying, hey, you're going to get 25, you should ask for 30 something million on this case, then at face value, you go, okay, well, that's not accurate because I should have gotten 50 on this because I did. But that's not the point. The point is it's learning. And this
Right.
whole process continues to learn. That was years ago. Every day, if you're using the LLM, it's getting better and better and better and better and better. And now you got Ben with his 1 to 2% deviation on it, which is fantastic to hear. And so I got an idea for you, Robert. You should
Go.
do a new thing, not VHS, VHSJ, Verdict Hub Shadow Jury, and then run all of the transcripts of both voir dire and each day. And there may be a way that Verdict Hub Shadow Jury can be used by lawyers to see how their case is going as another data point on a daily basis without too much sweat, and to continue to train your model on juror profiles and then how these jurors are going to react.
Yeah, we actually have that in the works.
Love
We've actually done it a couple of times. It's an expensive product. A live shadow jury. When we do a shadow jury, when we do a live shadow jury, we're in the courtroom. When the actual jury leaves, the shadow jurors leave. Lawyers get feedback over the lunch hour and at night every night. It's a really expensive proposition. It's like something along the lines of about $10,000 per day for every day of trial that you do it. Live shadow jurors, Mark calls them gallery jurors. We call them shadow jurors. They're really valuable, really expensive. We do that for VerdictHub also. We're still in the beta testing process of that, but it's like half the cost. It's like $5,000 a day. And I limited it to a 2-page report because lawyers in trial don't have any more time than a little bit to read a 1 or 2-page report, so that we limit it to 2 pages. We get just the highlights. But yeah, we are doing that role. We're going to be doing focus groups. That's kind of the model. That's what's coming up. The ultimate goal is to get to the point where our digital jurors are deliberating with each other in English, and the lawyers are watching it on the screen in their office. So the lawyers in their office would make a presentation, an opening statement for the plaintiff and the defense, and we charge the digital jurors, and we put them into a room, and they would deliberate. That's coming. We're not there yet. That's down the road, but that's on the horizon.
Great.
Robert, we really appreciate your joining us. If folks are interested in finding you and Verdict Hub in particular, can you tell them how to do so?
Yeah, absolutely. Verdict Hub, one word, jury verdict, verdicthub.ai is the website. And please, if we have any questions, if we can ever help you, we're here to help you. Look, we're really appreciative of everything y'all do. I know the stress it takes on lawyers. I know it takes the stress on your family, and I know how hard it is to do your job and do it well. But all of us are here to help you. So if we can do anything to help you, please don't hesitate to reach out, and we'll help you any way we can.
Thank you, Robert. You're doing amazing work, and thank you for being on the podcast. This was a lot of fun.
Thanks for having me, y'all. It's been my honor to be with y'all. I love you guys. I love what you do. And I'm warning both you. Rahul already knows this. Next time I see both you guys, you're getting a big hug from me. I'm just warning you.
Looking forward to it.
Me too.
Thanks, y'all.